Well, I find it hard to believe that privacy could encompass something this broad, nor do I think that the Founding Fathers supported it, nor was it the purpose of the 14th Amendment to grant this right to women. In fact, if you look at history, the majority of states who already had abortion laws on the books had them prior to the 14th Amendment passing, and it wasn't contested until nearly 200 years, or 100 years later with this case. In fact, the Supreme Court has already turned its back on the privacy in Planned Parenthood versus Casey, and they changed it to
Well, wait a minute now. Casey's in the future. You're arguing Roe v. Wade in 1973.
Okay, well, in Roe v. Wade, they only talked about privacy, relying on Griswold. I think that it's a completely different issue. This isn't just about whether or not you have the right to prevent a child. It is whether or not you have the right to destroy a child.
That's a fine distinction. It is.
And I think that the biggest mistake that the Supreme Court made in Roe is that they ruled that personhood was not something that they could determine at that time. They talked a lot about philosophical and theological ideas, but they completely ignored the science behind why these laws were put in place in the first place. They were actually put in place at the behest of the American Medical Association, who released a report in 1857 detailing the fact that they believed the medical science showed that life began at conception and that abortion was therefore an unwarranted destruction of human life.
That's a magnificent statement. Please have a seat.
Thank you.